It's important to a lot of people to get paid for the work that they do. And so we have a whole law regarding wages. The Fair Labor Standards Act is what it's called. And that does regulate minimum wage, overtime, and some other conditions of employment, things like that. The Fair Labor Standards Act has some exemptions so that some employees are exempt, all of the other employees are non-exempt. Some people use the word salaried employees to describe exempt employees. It's not exactly right, and hourly to say they're non-exempt. Salaried people can be covered by the Fair Labor Standards Act. Salary just means you're paid X amount per year or per month, no matter how long you're there, whereas hourly is you're paid X amount per hour, and they'll schedule you, and you should be productive for the hours that you're there. But if you're exempt, then fine. The employer doesn't have to follow the Fair Labor Standards Act with you. If you're not exempt, then the employer does have to follow those rules. As part of it, it does set out minimum wage, and pretty much anything the employer gives to the employees is considered pay. If the company pays for your house, if the company pays for your food, if the company pays for, just gives you money in a paycheck, all of that is earnings. You have to claim all of that to the IRS and pay taxes on it, but it does get a little bit messier when someone starts to work overtime. That pay, those things that they give you, goes into how much you should make. So how much should the company pay? And over time they have to make up with it with cash. They can't give you more of a house or an apartment to live in if you work overtime. So they consider that all part of your base pay, and that's added into how much overtime they owe you. Now that we know that everything the company gives you for working is a form of pay, is compensation, the next question is, well, what am I being compensated for? And there are a lot of things that people did argue over, but the rule of thumb is if the employer makes you do it, if you wouldn't have done it, if the employer didn't ask you to or make you do it, then it is compensable. If the employee wants to do it on their own, then it's not. Let's look at this chart. Everything here has been argued over before, but as far as a fire drill, that is compensable. You probably wouldn't be getting up from your desk at a certain time when an alarm went off to go outside to a certain spot to wait to get counted and to be accounted for by some other person and doing all that stuff if the company wasn't testing its fire systems. So that is compensable time. The employer wanted you to go outside, so you did. If you just took a break, if you wanted to eat lunch outside and you stopped working and went outside, the employer doesn't make you do that, that's not compensable. Things before you get hired, like the preliminary tests, like we talked about in the previous video, not compensable because you don't actually work there yet. So, rule of thumb, if the employer makes you do it while you're at work, then you get paid. If the employer doesn't make you do it and you're just doing it on your own, then you don't. The one caveat to that is the law says if the employer suffers or permits work. If you went to work and if you were being productive, if you were doing the thing that your job would have had you do on a normal day anyway, then the company has to pay you. They're suffering work, they're permitting work. They're permitting you to do the thing that you would have normally done, and if you were an hourly employee and you're doing it, the company has to pay you. And it's up to the company to send you home if they don't want you to be there working. So if you're at work being productive, you have to get paid. And if it's something that the employer had you do, then you get paid. But the employer can make rules. People can't just show up early for work and wait around for the beginning of their shift, but they're saying, oh, I'm here. You don't get paid for that. A company can't just willingly stay at work late and not punch out until later and get paid. The employer can make a rule against that and they can enforce it, and the company doesn't have to pay you just because you came to work you are being productive at work, the company has to pay you. And if the company doesn't want to pay you, it's up to the company to police its own facilities to make sure people aren't there doing the things that they aren't supposed to do. When we talk about the exempt employees, the most common exemption is the white collar exemption. These are the people that usually make a salary. There are two kinds of tests, a salary test and a duties test. And they have to meet both of them. The salary test is, they're paid a salary, they're not paid hourly. Just like previously in the course, if a company says someone is an independent contractor, the court doesn't care. It will look at the facts and decide for itself if that person is actually an independent contractor or an employee. It's the same thing here. If the company says, oh no, this person is paid a salary, the court won't care what the company says. It will look into it and say, oh, you said their salary, but you dock their pay if they work less than 40 hours. You said their salary, but you make them stay an X amount of hours per week. One thing, every once in a while, if there's like a special project and exception, it's not going to tip the person over to be an hourly person. But if a company has a policy that it docks a salaried person's pay, absolutely they're an hourly employee and they're not going to be exempt. They're not going to meet that salary test. You have to be paid a salary to pass the salary test. There's also the duties test. To pass the duties test, someone has to either be executive, administrative, or professional. And they're not controlled by their job title. What do I mean by that? Well, we'll separate those into the three different subjects: executive, administrative, and professional. Executive, these people are managers. Management is their primary duty. To be a manager, they have to actually supervise other people. An account manager is not a manager. You can't just put it in the title and that person becomes a manager. In order to be considered legally management, you have to actually supervise other people, you have to be highly compensated, and you make overall sort of high-level decisions and make policy for a company. Administrative, their duties are performing office work directly related to management, and they do exercise discretion. They are not management, but they support management. A manager might want to make a policy about something, but not know all of the details, and so they have the administrative employee study the subject, come up with a report, tell the manager what the actual statistics are, and that way the manager can make a more informed decision. That person is administrative. They're also exempt and highly compensated. Or that person is professional. They require advanced knowledge and discretion and judgment. Advanced knowledge usually means at least a college degree. Discretion and judgment is they do what they think is best. Think of a professional as like an engineer. They're not managing people. They're not setting policy. They're not doing research in order to set a good policy. But it does require advanced knowledge, and they kind of do what's best. They use this mathematical equation. This is the best way to reach that goal. Yes, there's more than one way to engineer a product, but this is what we think is best. Those people are professional. Let's talk about highly compensated. The law was just updated a few years ago. Highly compensated means you make at least $684 a week. That adds up to just over $35,000 a year. Anyone who makes less than $35,000 a year automatically is not exempt. They automatically have to get overtime, be covered by the Fair Labor Standards Act. If someone makes between $35,000 and $100,000, depending on the duties test, they might be exempt, they might not, from the Fair Labor Standards Act. If they're a professional, if they're an administrative person, if they're a manager, then they have the white collar exception. If they don't have those kinds of titles, even though they might make more than $35,000 a year, they still are covered by the Fair Labor Standards Act. They still have to get overtime and things like that. For people making over $100,000, no matter what, they're exempt. They're highly enough compensated that, according to the government, they don't need overtime, they don't need the extra cash, they don't need those kinds of protections. Let's talk about Keller versus Summit Seating for a minute. That was a case in the book. What happened is Ms. Keller came to work early every single day, and she did it for a long time. We're talking over 10 years. Something happened at work, and all of a sudden she demanded overtime because she had been working longer hours that she had been compensated for. She never really wrote it on her timesheet. She never did, I don't think she filled out a timesheet. She just never really told anyone. And then she comes back to say, hey, you owe me all this money because I've been working overtime the whole time. The company would have had to pay if she won. In this case, she lost, so the company didn't have to pay. What she said was that she came to work early every day. She got there before anyone else, so it was just up to her to say what time she got there. She didn't punch a time clock, so they never knew. And she said she did work while she was in the office. She worked in an office, but she was an administrative assistant sort of thing, someone who would not be exempt from the Fair Labor Standards Act. When questioned about, what she did at work, she did important things like turn on the lights and arrange some of the fabrics. It was a Summit Seating. It made seats. So, she arranged some of the fabric. She got everything in order. And it wasn't part of her job to arrange the fabrics. It wasn't part of her job to help any of the hourly people. And doing things like turning on the lights isn't a big enough part of the workday or her job duties to require extra pay. I think she also admitted to making coffee and going out and smoking cigarettes sometimes, but those were not work. But the company allowed her to take cigarette breaks and didn't dock her pay for that, so they should pay her for that other stuff. A bunch of people testified that they didn't think she was being productive, and when they got there, not much had been done. And so the court ruled that she didn't get it because she wasn't doing her work. Had she been going into work and doing her work and being productive, then they would have paid her. But she didn't. She just got to work early and all of a sudden was demanding extra payment. Another part of this case is that management didn't know that she got there early because she never told them. And there weren't cameras and there weren't time clocks that she punched. And so they didn't know. So their defense was they didn't allow her, they didn't permit her to work, they didn't suffer work because they never knew she was there in the first place. The court thought this was a little bit iffy, and maybe it would have gone differently if she was being productive and doing her work, because it's up to the employer to police their own workplace. But if they had known she was there, it would have been up to them to tell her to not come in early, to either come in early and be productive and they would pay her, or to just not come in early, and at least she would know up front that she wouldn't get paid. So just because someone comes in early doesn't mean they get paid. But if they come in early and are productive, then you have to pay them, even if it means you have to pay them overtime. This raises another question about what if someone has multiple duties? What if their job description has multiple duties in it, and some of them are administrative and some aren't? What if some of them are professional and some aren't? Well, what they do is they look at the primary duties test. And this is kind of pointed out in the Myestas versus Day Zimmerman case. That case was regarding an EMT security sort of firm. They did a bunch of stuff. And there were 4 people that sued that thought they were owed overtime. All of them had multiple duties associated with their job. And all of them said, we were at work, we worked more than 40 hours. They were saying we're not exempt. We fall under the Fair Labor Standards Act, and you owe us overtime. The company says, no, you are exempt. You're doing management duties, so you don't get overtime. And that was the argument. There were 4 people suing. It turned out 3 of them got the overtime and 1 didn't. But what they did was they did the primary duties test. The 3 that got it spent most of their time out in the field. 90% of their time, 92% of their time. I'm not going to go through all four, but as an example, one of them who got the overtime spent 90% of his time out in the field, but he also was the person in charge of scheduling everyone. So he spent a few hours per week scheduling all the other employees, the Dave Zimmerman employees, when they were going to come in, what shift they were going to work, what hours they were going to be there, all of that sort of stuff. And that would normally be a management function. You're directing work of other people. But he only spent a few hours a week doing it. The rest of the time he was out in the field actually doing the work. The one person who did not get the overtime was out in the field about the same amount of time that the other guy made the schedule. A few hours a week he got out into the field and did that kind of work. The rest of the time he spent in the command center. He was always involved in making policy, and he directed the work of other employees. Manager was not in his title, it was not in anyone's title, but the court decided he was much more of a management employee, directing the work of other people and creating policy, than he was an active employee. So he was exempt as a manager from the Fair Labor Standards Act. The other employees, although they performed some management roles, were not exempt because their primary duties, the most they were used by the company, was to be a frontline employee. So they were not managers. So the Fair Labor Standards Act covers most employees in this country. It doesn't cover everyone. Some people are exempt from the law, specifically in the law, but some other employees are agricultural workers or migrant workers. They don't fall under the Fair Labor Standards Act. There is the Migrant and Seasonal Agricultural Worker Act that does cover them because their work and their whole employment system is so different than most of us that they got their own act. But basically, there is no minimum wage for agricultural workers. There's no minimum wage for migrant workers. Basically, the company has to be upfront with the employees about how much we're going to pay, what the conditions are going to be, how it's all going to happen to go down, what the expectations are. They report those also to the government, so that the government, if it gets one that's like way out of line, it can be like, hold on a minute. But a lot of times, those companies, the employers, provide housing, provide transportation, provide all that stuff for that kind of people. They might house them in a hotel, or they might own like a dormitory style building or something. And then every morning, the workers will get on a bus and they'll take them to an apple orchard and they'll pick apples. And then they'll come back, and then the next day they might go pick cherries. Or they might go to a different apple orchard. Or they might go pick lettuce. Whatever it is, those people don't live there permanently. They're migrants. They're agricultural workers. Part of that housing is their pay, even though there's no minimum wage. They are paid a little bit, but pretty much those employers have to be just very upfront with them so that people know what they're getting themselves into and how much money it's going to be, and and what they're going to get. And that's to prevent abuse of agricultural workers. The Fair Labor Standards Act does not limit the number of hours you can work. That's something that a lot of people think, they do. No. Your employer can make you work as many hours as they want. As long as they pay overtime over 40, they can force someone to work as many hours in a week as they want. If you don't like it, you can go get a job somewhere else. That's the attitude of the law. But if you're under 18, there are other, child labor laws that apply instead of the Fair Labor Standards Act. So the only thing the Fair Labor Standards Act says about child labor is that you can't have oppressive child labor. There are certain things you can't do, any dangerous work or that sort of stuff you can't do as a child. Anyone under 18 can't work with explosives or certain chemicals or things like that. It gives some more rights. People usually between 16 and 18 can do most jobs. 14 and 15-year-olds, it's even fewer jobs they can do. My first job, I guess, I was a soccer ref. I used to ref soccer, and you're allowed to start reffing soccer when you're 14 years old, and I did. So those sorts of things are allowed for 14-year-olds. If you read the Michigan law, you can have bridge caddies as young as 12 years old. So the bridge players had a really good lobby in Lansing, or maybe just a bunch of people really liked playing cards. But certain things are written into the law that you can be a bridge caddy when you're 12. You can be a soccer ref when you're 14. You can just go get a normal job when you're 16. Limitations: you can't work in a place that takes cash after 9 o'clock or dark, whichever happens first, to protect children against robberies and those sorts of things that happen. And then once you're 18, you're fully covered by the Fair Labor Standards Act, and you can work dangerous jobs. You can work as many hours as your employer wants, as long as you get overtime. That sort of stuff is there. So we have the Migrant and Seasonal Agricultural Worker Act. We have Child Labor Act, and those both cover the people that aren't really covered under the Fair Labor Standards Act. But the Fair Labor Standards Act is what most people in this country have to follow. And it's mostly about overtime and sometimes about minimum wage. There's more to the law. That's where most of the arguments come from. About pay, we're also going to talk real quick about the Equal Pay Act. Women have to get paid the same as men. It's usually a woman versus man, although other minorities don't get paid as much as white people either. So it can be used for the same thing. In order to prove a case of pay discrimination, there are 3 elements, and the person basically has to prove that they work for the same company in the same place, doing the same job as someone of the opposite sex who's making more money. There is a requirement for it to be at the same company in the same location, because people working at Starbucks in Detroit might not make the same amount of money as the people who work at Starbucks in San Francisco. It's a different market. They're going to make different amounts of money. The amount that people make at Starbucks in Birmingham are also going to probably be different from that of Detroit, even though it's the same market. Also, people working at a different kind of coffee shop, people working at Beaner's Coffee might not make the same as Starbucks, but that doesn't mean they're discriminating. It's just a different company with a different pay theory. So it has to be the same company in the same location. Also, they need to be doing the same or substantially the same job. Still using Starbucks as an example, if someone is a barista, they have to compare themselves to another barista. Someone can't compare themselves, hey, I'm a barista and my manager makes more than me. Well, yes, managers make more. So that's not a fair comparison. Basically, there's a comparator, the person who they are comparing themselves against makes more money doing the same job that I'm doing. And that's pay discrimination. Of course, the company has an opportunity to defend itself. The company might say there's merit pay, so this person could have been here longer. Also, they could have been here longer. There's seniority pay, seniority-based pay. So it's not their sex that it matters. It's just the fact that they've been here longer. Commission. This person sells more, so they make more. But be careful, because in certain businesses, men sell things more easily than women. Men usually outperform women at car dealerships. They're paid on commission, but there are people that are still weird about buying a car from a woman versus a man. So men's sales are usually higher at car dealerships because the men just sell more cars because more people are more comfortable buying cars from men. So as part of a pay discrimination case, what they do is a job evaluation to make sure these people are working the same or substantially the same jobs. It's easier if I'm a barista and someone else is a barista and I want to compare myself to them. Okay, that's fine. But there are often times where people have different job titles, but they're doing substantially the same job. So what the court looks at is the skill, the effort, the responsibility, and the working conditions of that job. For skill, how much skill does it take for this job? Does this job have an education requirement? Is there a technical skill that I need to know for this job? And is there a technical skill, the same skill, that I need to know for the other job? So they'll look at that to see if there's the same skill. Effort, same thing. How much effort do I have to put in for this job? Is this job physical? Is it just sitting in an office? Is there mental exertion that's required for this job? If it's similar, then we can make a comparison. Do I have the same amount of responsibility? Like I said, it's understandable that a manager gets paid more than the employee. The manager would be seen as having more responsibility than the frontline employee. So if they have the same amount of responsibility, then they're more alike. And working conditions. Do we both work in an office? Do we both work outside? Do we both work in a dangerous condition or not? The person who works in a dangerous condition understandably would get paid more because there's more on the line with their job than if I'm doing the same job in a much more safe environment. But those are the four things that they look at. In the City of Dayton case that's listed in this chapter as well, is a good example of all of that. What there was an HR person who worked for Dayton in Ohio, the city. And she had been there quite a while, and a man was hired in, and she eventually sued, saying he made more than she did. He made substantially more than she did. Dayton argued, well, there's two different job descriptions, so it's the same. Well, there were two different job descriptions and two different sets of requirements for getting the job. They looked at all of that stuff going through that job evaluation and said, okay, well, yes, there are different job titles and job duties. Well, job duties were similar, but job requirements, and her job required a bachelor's. His only required an associate's degree. She had been at her job longer, so as far as like it being a seniority or a merit pay. He had been at the job less time. They took substantially the same amount of effort and mental exertion. They were both office jobs, and both of them had the same responsibility. I mean, they made policy for the city, in the HR department, but they didn't manage people. And so they eventually said, yeah, the job is the same, is substantially the same, so that covers that. The next thing the city said to defend itself was, well, and this is where it gets interesting, well, he made more money at his previous job, so we had to pay him more in order to attract him here. That's very common. Someone made more money, so I have to pay them even more than that to lure them to this employer, to this company, to this, the city to work. The court does not accept that as a defense. Because when we talk about structural discrimination, men get paid more than women. It's a statistic fact that men get paid more than women. So, no one doubts he got paid more at his previous job, but that's not an excuse to pay her less than him now. That doesn't mean her work is less. That doesn't mean she's valued less. That's like a systematic problem, and the only way we're going to solve it is if we don't allow that to be taken as a defense from the company. So just because someone made more money before doesn't mean I can unfairly pay him more now. The company, the employer, the city of Dayton had a choice. They could either just not pay him less and risk not having him as an employee, or they could bump her pay once he got there. But that was not an excuse, and that was not a defense for the company paying him more. They were doing substantially the same job, and if anything, her job had more requirements to get than his did, but she was getting paid less, so she won that lawsuit. And finally, for this video, I want to talk about pay secrecy policies. Almost everywhere I've worked that hasn't been a government thing, like the university, has had a pay secrecy policy, and they are sure to tell you, don't discuss your salary with other people. I've had some places be very strict about like, you don't discuss your salary. I've had some other places that use more like social pressure and literally say to people like in orientation, like, it's just not very classy to talk about money, so let's just like not talk about it. Those are illegal. Those are illegal through many laws. They're written into a lot of laws. It's written into the National Labor Relations Act. It's written into the Fair Labor Standards Act. It's written to a bunch of laws. The reason for that is the woman in Dayton would have never known she made less money than the man if they hadn't talked about their salary. If there's a pay secrecy policy, then the employer can fire her for complaining about her salary, and fire him if it wanted to. And then there would have been no lawsuit because she would have been fired for breaking a rule, for breaking a policy, the pay secrecy policy, and not getting fired for illegal pay discrimination. So, pay secrecy policies are illegal. A lot of companies have them. A lot of places threaten. I've personally never seen anyone fired for breaking a pay secrecy policy. But there are a lot of companies that pay a lot of people a lot of different wages, and that pay secrecy policy is at least intimidating enough that a lot of other people don't talk about their pay. But the only way to correct a pay discrepancy or pay discrimination just in society is to make it illegal for a company to make a policy against a lot of negatives, to make sure that people are allowed to talk about their salary. So if a company has a pay secrecy policy that's illegal, and they might still have the policy, but they can't enforce it. They can't fire someone, they can't discipline someone, they can't do anything for someone talking about their salary with another employee. That's the only way people will know, and that's the only way we're going to correct pay discrimination in the way American society has it set up. If we want, we can be like Sweden, which every single year on tax day, Sweden releases everyone's salary in the whole country. Anyone who lives in Sweden, you can go to the government website and look up their salary so everyone knows what everyone else is getting paid. So if I wanted to make sure I was getting paid the same amount as other people at my work doing the same thing, I could just go online and look. That's Sweden's way of battling pay discrepancy. We don't do that here. So the only thing we can do is make sure people are allowed to talk about their salary with each other, and then they can talk to their boss about it. If their boss still says no, they can sue for it. And so that's the way we're going to correct pay discrimination. So Fair Labor Standards Act, that's the law that talks about minimum wage and overtime and all that other stuff, and you can't discriminate with pay. So I hope you know more about the way people are paid and what you have to do, and I'll see you in the next video.